Imagine being awakened from a sound sleep by a group of armed men bashing at your door. Come to find out, it's the FBI. Oh yeah, and they have the wrong house. Now, after the trauma, not to mention the damage to your house, at the very least you can sue for a redress of these grievances, right? Well, that is the question before the Supreme Court in the case Martin versus United States. So we'll look at that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our next generation be free. I'm glad you could join me today. This is an interesting case because I've seen more and more of these examples of, well, wrong house raids. This one happens to be an FBI raid, but there's an interesting question of, well, is the government liable when the law enforcement makes a mistake? So we're going to dig into that. And there's a lot we have to cover. Before I go, though, if you want to find out the details, if you want to check my sources and links, well, go to the website, constitutionstudy.com, and you can find the article with all the links attached to it so you can double-check my sources. But for now, let's get into this question of Martin versus United States and what happens when the FBI raids the wrong house. Before we get into what happened that led to this case, there's an important point that is not obvious from the arguments. This is not a case about the FBI raiding the wrong house. It's about whether or not the victims of this raid can seek a redress of their grievance. From the petition for certiorari, we read, in the pre-dawn hours of October 18, 2017, FBI Special Agent Lawrence Guerrera led a 6-agent SWAT team to 3756 Denville Trace. Failing to confirm the address posted on the mailbox and using a black Chevrolet Camaro in the driveway as a landmark, Guerrera mistakenly believed he had arrived at 3741 Landau Lane, the home of gang member Joseph Riley, and the address for which Guerrera had a search warrant. Now, at the time, Guerrera knew that the target house had its address posted on the mailbox and that neither Riley nor his associates were known to drive a black Camaro. Ignoring these and other conspicuous features that could have averted their mistake, the heavily armed FBI SWAT team smashed in the front door of 3756 Denville Trace, detonated a flashbang grenade in the home's entryway, and rushed inside. This led not only to damage to the property, but severe psychological trauma to the family as well, especially the young son. When the family attempted to sue the United States under the Federal Tort Claims Act, both the district and circuit courts denied them standing. Which leads us to the question presented to the Supreme Court with Katrina Martin as the lead plaintiff. The questions presented are whether the Constitution's Supremacy Clause bars claims under the FTCA, a federal statute enacted by Congress, when the negligent or wrongful acts of federal employees have some nexus with furthering federal policy and can reasonably be characterized as complying with the full range of federal law. Second, whether the FTCA's discretionary function exception bars claims for torts arising from wrong house raids and similar negligent or wrongful acts by federal employees. In layman's terms, does the Constitution's Supremacy Clause prevent lawsuits against the federal government whenever federal employees are doing their jobs? And does the FTCA prevent suits if the federal employee is exercising discretion in the performance of their duties? Now, as always, the person bringing the case to the court, the petitioner, goes first.
Mr. Chief Justice, and may it please the court. Congress amended the Federal Tort Claims Act in 1974 to ensure a legal remedy for the intentional torts of federal police.
Legally, this all starts with the Federal Tort Claims Act, passed in 1948. This legislation was passed to deal with the problem of sovereign immunity, something I'll look at later. The two sections of the law we need to focus on are sections 2674, liability of the United States, and 2680, exceptions. The United States shall be liable, respecting the provisions of this title relating to tort claims, in the same manner and to the same extent as a private individual under like circumstances, but shall not be liable for interest prior to judgment or for punitive damages. While Section 2680 listed several exceptions to United States liability, there was still a problem, which is why in 1974, Congress amended the FTCA with the following proviso: that with regard to acts or omissions of investigative or law enforcement officers of the United States government, The provisions of this chapter in section 1346B of this title shall apply to any claim arising on or after the date of enactment of this proviso out of assault, battery, false imprisonment, false arrest, abusive process, or malicious prosecution. However, the 11th Circuit held that sovereign immunity prevents any such lawsuit from being heard, even though Congress explicitly said otherwise.
Petitioners bring the claims Congress expressly permitted, but the 11th Circuit held that sovereign immunity bars them.
While the arguments focus on many issues in this proviso, the petitioner's point is rather simple.
So the government's argument in this case and the 11th Circuit's holding below invite a simple question. If even proviso claims Congress amended the statute to affirmatively guarantee are barred by sovereign immunity, what is left of the Federal Tort Claims Act?
Does the court's idea of sovereign immunity supersede federal law? It is a question we'll look at closer later. Next, let's look at the arguments made on behalf of the United States.
Mr. Chief Justice, and may it please the Court. This Court granted cert on two questions, one about the reach of the proviso in subsection H, and the other about the Supremacy Clause. To resolve this case, this Court need only decide the question about the proviso, namely, whether the proviso in subsection H modifies the discretionary function exception in subsection A. The answer is no. Congress placed the proviso in subsection H, and given that choice, the proviso modifies only subsection H.
According to Mr. Liu, while two questions were brought before the court, only one thing needs to be decided: a small question of construction and English grammar in the law. When Congress added the proviso to subsection H of section 2680, did it modify that subsection, which I quoted before, or the entire section? Now, this is important because subsection H provides an exception to a person's right to sue for any claim arising out of assault, battery, false imprisonment, false arrest, malicious prosecution, abusive process, libel, slander, misrepresentation, deceit, or interference with contract rights. In other words, even if the government actors grossly violate the law and your rights, the 11th Circuit claims the FTCA's discretionary function exemption prevents you from seeking redress. Now, what is this discretionary function exemption that Mr. Liu is talking about? Any claim based on an act or omission of an employee of the government exercising due care in the execution of a statute or regulation, whether or not such statute or regulation be valid, or based on the exercise or performance or the failure to exercise or perform a discretionary function or duty on the part of a federal agency or an employee of the government, whether or not the discretion involved was abused. Basically, this is a get-out-of-court-free card for any federal employee while on the job. If the law or regulation is invalid, no lawsuit for you. If the federal agent or employee abuses their discretion, no lawsuit for you either. In short, it means the government actors can do pretty much whatever they want as long as they can somehow tie it back to them exercising discretion in how they do their jobs. The court invited Mr. Christopher Mills to brief the court on this case as an amicus curiae, or friend of the court. He argued in support of the 11th Circuit's decision on the first question presented, that the Supremacy Clause bars claims under the FTCA.
Mr. Chief Justice, and may it please the Court, the FTCA does not make the United States liable for lawful acts of its agents.
No one should be liable for lawful acts. The question that petitioners are trying to get heard is, were the acts of the FBI lawful or not? That is the crux of the argument. Now let's get into the questioning and the specific issues raised during arguments. This whole mess comes down to the idea of sovereign immunity, a remnant from our days as British colonies with a sovereign king who could do no wrong. However, when we broke away from Great Britain, we also broke away from the idea of sovereign immunity. Sovereign, a chief ruler with supreme power, one possessing sovereignty. It is also applied to a king or other magistrate with limited powers. In the United States, the sovereignty resides in the body of the people. The first problem with the concept of sovereign immunity in the United States is that courts have the wrong sovereign. Sovereignty, the supreme power of the United States, resides with we the people, not the government. It also violates the Supremacy Clause and the First Amendment, which we'll get into later. That doesn't stop Congress from trying to write such a constitutional violation into the law. Congress's attempt to blow a gigantic hole in the Constitution started with the so-called discretionary exception of the FTCA. However, in the past, the Supreme Court had tried to keep the reins on federal law enforcement. This was the topic of an interesting back and forth between Justice Sotomayor and Mr. Liu.
Interesting, because in Garbert we said if an official drove an automobile on a mission connected with his official duties and negligently collided with another car, the exception, discretionary exception, would not apply. That was because, and I'm quoting, although driving requires the constant exercise of discretion, the official's decision in exercising that discretion negligently, I'm putting in that word, can hardly be said to be grounded in regulatory policy. I mean, I don't see the difference between that and saying that an officer's action in using a GPS to break into the wrong house has any policy related to it. It's like driving negligently. You got to that house by mistake. You drove negligently and hit someone. So I don't understand how the act of going into a wrong house can be discretionary.
Interesting question. Does the fact that the federal agent is working within the discretion of their job give them protection from their negligent acts?
Well, we understand the discretion here to be the discretion as to how to identify the target of a search warrant.
Okay, the agent had the discretion on how to identify the target, or more specifically, the target's location. But don't they have a duty to make sure that they are at the correct location, especially consider they plan to and did use violence, using potentially lethal force during the conduct of the raid?
He had it identified. He got the right target. He just had the wrong house. It's not a question of did he make a mistake in his warrant application about this individual being a drug dealer. All right, there I might agree with you. Okay, I'm talking about a wrong house raid. He has the right target, the right house, but breaks into the wrong one.
Right, and it's because, as the courts below found, of a reasonable mistake that the officer
that's
made.
the issue. Is that consistent with Gaubert? And I'm asking you to explain to me how that formulation is consistent with Gaubert.
When you or I make a mistake, we're liable for it. So why not federal law enforcement? The officers made a mistake. I don't think anyone disagrees with that. But who is responsible for the consequences of that mistake? If the purpose of the FTCA was for the United States to assume liability for the bad actions of their employees, why place such wide-ranging exceptions on that liability? That is, unless you are planning to deny people their right to petition the government for a redress of their grievances. This led to another interesting exchange, this time between Justice Gorsuch and Mr. Liu.
No policy says don't break down the wrong house, door of a house.
No, excuse me. Of course, it's
don't traumatize its occupants. Really?
Of course, it's the United States policy to execute the warrants at the right house.
I should hope so.
But stating the policy at that high level of generality doesn't foreclose or prescribe any particular course of action in how an officer goes about in identifying the right house.
So there's no rule about how federal officers identify the right house, but does that absolve them of the responsibility when they get it wrong? Mr. Liu's response was priceless, and not in a good way.
The officers here were weighing public safety considerations, efficiency considerations, operational security, the idea that they didn't want to delay the start of the execution of the warrants because they wanted to execute all the warrants simultaneously. Those are precisely the sorts of policy trade-offs that an officer makes in determining, well, should I take one more extra precaution to make sure I'm at the right house? Here, petitioners suggest, for example, that the officer should have checked the house number.
Public safety, operational safety, these were the concerns of the officers. Well, the public wasn't safe because they attacked an innocent family. Operational security was blown, too, because they were close enough to the correct house to alert the subject the FBI was after him. Tell me, how did the safety of an innocent family balance those policy trade-offs?
Yeah, you might look at the address of the house before you knock down the door.
Yes, and as the district court found at 52A, that sort of decision is filled with policy trade-offs because checking the house number at the end of the driveway means exposing the agents to potential lines of fire.
How about making
windows?
sure you're on the right street? Is that?
And how does that?
Just the right street.
No, I mean, I was just going to
checking the street sign. Is that? asking too much?
What I would say is exactly what the courts below found, which is that the officers here made a reasonable mistake as to where they were. The allegation from petitioners' claims is that they should have done more. They should have stopped and got out of the caravan of vehicles and checked the streets.
Yes, the officers made a mistake, a big one. It wasn't reasonable. It was negligent. Officers didn't need to stop outside and exit their vehicles to check the address. All they had to do was drive by and look at the mailbox. Should the officers be forced to tell the family, including the traumatized child, that their safety wasn't worth making sure the GPS sent them to the right address? Even I double-check the address when I follow my GPS. I've already talked about the discretionary exception from subsection A and the proviso, but where did the proviso come from? Well, answering a question from Justice Alito, Mr. Giacomo said,
and I think that's doubly important here because, again, Congress went out of its way in 1974 to go through all the steps it needed to go through to specifically amend the FTCA to say this very affirmative freestanding thing. If you're a federal law enforcement who commits an intentional tort, we, the United States, not you, the officer, will pay for it to make sure that there's a remedy for the innocent victims of your mistake or wrongdoing.
If the purpose of the proviso was to make sure the United States would be liable for any intentional mistake or wrongdoing by federal law enforcement, how can that not apply here? Mr. Liu argued that the proviso only amended subsection H, which makes sense. But if the intent of Congress was to provide a remedy to innocent victims of federal actions, could that be outdone by another subsection? Even though the proviso specifically states that with regard to the acts or omissions of investigative or law enforcement officers of the United States government, the provisions of this chapter and subsection 1346B of this title shall apply. Seems like the 11th Circuit is trying to undo the law made by Congress with grammatical legerdemain. While there was a fairly wide-ranging discussion about the different proviso opinions, the arguments from the United States and the court's amici boil down to this.
It simply means that when the federal agents are performing their federal duties, the United States can't be liable in money damages.
No matter what government actors do, according to the federal lawyers, no one can be held accountable for their bad actions, intentional or otherwise. However, as Mr. Giacomo stated in his rebuttal,
as my friend said, the government's policy is to raid the right house. They didn't do that. The preparation is kind of immaterial to the ultimate result here. If you really, really meant to drop the pizza off at the right address, it doesn't matter. You still need to give a refund if you drop it off at the wrong address.
The intentions of the officers shouldn't matter. They screwed up, raided the wrong house, and terrorized the wrong family. Shouldn't the government redress those grievances? According to the 11th Circuit, they cannot because of sovereign immunity. But as I've already shown, sovereign immunity is an antiquated concept incompatible with the Constitution. Let's start with the Supremacy Clause. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. There is nothing in the Supremacy Clause to support the 11th Circuit's contention that it prohibits lawsuits under the Federal Tort Claims Act. There is also no language in the Constitution that grants immunity for the acts of federal employees. The Constitution is the supreme law of the land, not some government sovereign. Not even Congress can legally supersede the Constitution, since only laws made in pursuance of the Constitution are considered supreme, which means that while the FTCA is constitutional, the exceptions are not because they violate the First Amendment. Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. By abridging the right of the people to petition the government for a redress of their grievances, the exceptions in Section 2680 are unconstitutional, invalid, and void. As usual, we'll have to wait and see how the court decides this case. If it were only a question of the law and the Constitution, it'd be easy to predict. However, as we've seen so often with this and other courts, it's less a question of the law and more a question of the mood of the justices. Personally, while I find the actions of the FBI both negligent and reprehensible, the actions of the district and certain courts are irresponsible, culpable, and impeachable. Those judges took an oath to support the Constitution, an oath they denigrated with their vile abuse of power. So that's the question. Do federal employees get a get-out-of-jail-free card? As long as you can somehow tie it to doing your job, any crime you commit, any negligence, any outright malfeasance gets washed away. That's what the court came up with, then that's what Congress, well, they tried to fix by moving the responsibility from the individual to the United States, but then they threw in a bunch of these unconstitutional exceptions saying, no court for you. You don't get a redress. That to me is not simply wrong. That's impeachable. That's criminal. You are denying people their right to petition the government for a redress of grievance. You are denying them their right under color of law, which is, by the way, a federal crime. 18 U.S.C. Section 242. It's why we need to know and study and understand the Constitution and how we can use it to defend our rights. Now, I try not to prognosticate, so I'm not sure how this court's going to answer. It does seem like they're leading towards the Martins side, but we have to wait and see. This is getting late in the term, so it shouldn't be too much longer before we get an answer. But I've got so many court cases going on, I'll get to it as soon as I can. Now, if you like the work that we're doing here and you'd like to help support the Constitution Study, well, the first thing you can do is go to the website, constitutionstudy.com. Sign up for a mailing list. Share some of our content. Maybe head to the store and purchase a book or a mug or a t-shirt, or just donate to the cause. You can do a one-time or recurring donation. All of that goes to putting these videos and the rest of the content the Constitution Study puts out on. I don't take a salary from this. I pay for all of this. So help support the work that we're doing. If you like it and you want to keep receiving it, do what you can to help. You can also help by supporting our affiliates. For example, the course, The Miracle of America. I made a deal with them to get you a lesson absolutely free. Go to constitutionstudy.com/1776 study guide. Read up about the course, read up about the instructor, and then sign up for your free lesson on God's natural law today. Absolutely free. That's great. If you like the course and you decide to take the course, well, it's just $17.76 and help support the work that we're doing here at the Constitution Study. Another way you can do that is with your cell phone. I joined Patriot Mobile several years ago because, well, they're America's only Christian conservative wireless provider. Yes, I get great coverage, 4G and 5G across the nation. Yes, their customer support is 100% U.S. based. But I joined them because a portion of every dollar is donated to organizations defending our rights, including our freedom of religion, freedom of speech, and, well, our right to be secure from unreasonable searches and seizures like the FBI knocking down your door. Go to patriotmobile.com/Constitution today to sign up for a plan that works for you, and be sure to use the code Constitution at checkout to get free activation. Not only do you get great cell phone service, great Wi-Fi service across the country with great customer support, you're also helping to support the Constitution Study as we help teach people to defend and assert their rights. Probably the best thing you can do, and it doesn't cost you a dime, is simply share this information. Share the video, share the article, share the links, share the knowledge. Let other people know there's a place they can go to read and study the Constitution, teach a rising generation to be free, and learn how to defend and assert their rights. By doing that, you're not only helping support the Constitution Study, you're helping to teach this generation and the rising generation how to be free. I also hope you'll come back next time and, hey, maybe bring a friend or two when we meet for the Constitution Study.
Love your neighbors and have a few good friends.